Okay. Fantastic.
Welcome, guys, to Billionaire Acquisition Mastermind, #1 M&A podcast in the world. And if you're not subscribed, make sure you do. So today we're bringing on a special guest. His name is Andrew THOMPSON. He's been involved in all aspects of a transaction, but primarily he's legal counsel to buyers and sellers. Andrew, thank you for being on today's episode. I appreciate your time.
It's great to be here with you.
So when Andrew saw our podcast, he noticed that we haven't touched on the legal side of things and decided to share insights in that area. So make sure to thank him for that. So let's get started, Andrew. We're going to run through our questions and then, at the end, if members have any. One thing I want to touch on is how important is it to have internal legal counsel? And we were talking about this, having somebody with legal experience in your team to guide you, especially if you're new.
Yeah, I think it's incredibly important. A lot of startups try to operate, honestly, similar to a nonprofit organization where you might have someone serving on your board who doubles as sort of pro bono legal counsel, always with the intent of sharing equity with that person. The problem that comes in is obviously if you're in a nonprofit organization, there is no equity, there's no stock in the company, there's no membership units that have equity value to them, which of course the whole purpose of a startup organization, startup entity, for-profit entity is to grow and earn a profit. When you take an ownership stake in a business and it's not 100% your own, then there's a pie and you're a piece of that pie. So there's a natural inherent competition, at least as the law sees it. And that can present and does present an inherent conflict of interest between the counsel and the team. So the reason I bring that up is because when you bring on legal counsel internally, the challenge is it's very hard to find someone who will serve as a director for an equity stake and then also act as your general counsel. In most states, it's not forbidden, but it's very problematic for an attorney to act in that way. And many large firms actually do forbid it internally. So having general counsel, having in-house counsel is very important because, as you and I have discussed offline, Valentino, as you come to the point of a deal, as you're approaching making an offer, presenting a letter of intent to a seller, as you go through that process, you want it to be vetted legally, but it's really often premature to retain outside counsel to expend the extra funds because what you're doing is very much an in-house type of offer, and you're going through the process that doesn't involve a negotiation attorney to attorney typically. Now, I'm not saying you can't use outside counsel for a letter of intent, but you've got steps approaching that point in a deal that it's going to be very helpful to you to have in-house counsel looking over what you're doing and advising you on your risks, as well as the opportunities that are associated with them in taking those steps.
Absolutely. And one thing I tell people is anything prior to an LOI is very premature. It's very early stage. So coming into an outside firm with a deal under, a letter of intent, with agreed upon structure and a price that makes sense changes, the perception, right? You're coming in more professional. You're coming in prepared with a deal you're ready to execute upon, not just a so deal. We got something, you might be interested.
Right. I totally agree with that.
So one thing that people don't touch on, but in regards to legal documents, is not only important what you include in the document, but also what you don't include. Can you touch on that, Andrew?
Well, the thing is that you can think about your documents that are associated with an acquisition agreement, which is typically for assets, an asset purchase agreement, and all the associated agreements. If you have an escrow, if you have a non-competition, other agreements that are attached to it. Anything that's not in the agreement lies outside the agreement. So if I took the whole body of work that I have negotiated with other attorneys and looked at each deal side by side, there would be many clauses in each deal that were left out of another deal or perhaps all other deals. So you have to think of it, it's kind of like if you live in a neighborhood, a subdivision, your yard versus all the yards in the neighborhood, everything that's outside of your boundaries or your fence that surrounds your yard is not your own. And your documents only represent the transaction that you do. But they not only represent the transaction, they represent the very terms of those transactions. So it's kind of all about how you landscape, decorate, maintain that property that you have for yourself. Everything else is outside the agreement.
Absolutely. Appreciate you going in depth. Now, this is a big one. If you require a license to operate a business, like in most cases with healthcare and other types of industries you do I have to purchase a legal entity, a stock purchase instead of an asset purchase?
Not necessarily. In most states, you are not going to have to acquire stock in that particular business if you're already licensed and if you already have an entity. The problem is, I think in every deal, you're looking at, okay, so the way I structure a purchase agreement for the vast majority of asset deals that I do is to create a new entity, usually often, well, I shouldn't say usually, but often with the very same name as the old entity. So you're also buying the naming rights as well as other assets of the entity. So it just depends on the situation, Valentino. And I guess I would need more specifics to know whether there would be a requirement that you would have to purchase stock or not. But typically, right. I would say in most states, the answer to that would generally be no. Now, California, for example, sometimes New York, they have gone 2 or 3 degrees further in terms of the requirements that they have around purchasing assets of an entity on a professionally licensed basis. But in most states, you generally wouldn't have to do that. But of course, there are some exceptions.
Right. So let me give you an example. Let's say I look to acquire a home health company, right? And we need a license for a home health. Well, like you said, if we create a new legal entity that's going to take over the assets of that company, we could just merge it alongside its name, but I don't have a license to operate. So taking that in consideration, could we keep the owner on board for a 12, 18-month transitory period, operate under his license, and in the meantime work to get ours?
Absolutely. Absolutely. In fact, that would probably be a recommendation you would be likely to get both from in-house counsel and external counsel on that type of deal. Now, here's the thing. I mean, of course, the part of the value in the acquisition is to replace the presence, the goodwill of the current owner with your own goodwill, because the sooner you can do that, the more you can capitalize on your own name or the names of the management team that you're putting into place. But that said, you have a situation where, like you said, when a home health agency, you may want or actually need the previous owner to stay aboard for a longer period of time than you would typically seek to have them involved with the new business entity. The other thing to think about there, and then this may be one of your questions later on, is what are you going to do with the previous owner once they do entirely exit from the business? Because oftentimes the buyer's greatest concern is that they're going to end up competing with someone who has already built up a name and goodwill in the geographic region in the same business that they're in. So that's something you have to bear in mind. And it's part of the reason why buyers like to get previous owners as far away as quickly as possible as they can. But in the situation you've described, I always encourage my buyers to think through the process of how they're going to work in the transition with the previous owner. And when you have licensing issues involved, that's a very important reason to consider keeping them aboard longer and taking advantage of all the training that they can offer you as you come into the business.
Right. So let me share with you what I know about the transition from the purchase, of the business, and then you correct me. So what I know is that banks, because we're looking to fund this with commercial debt, not only do they look for the numbers to be stable, but they also look for continuum of management. That is key, because here up till now, these people that have been working in the company have been able to produce this amount of money. Taking that into consideration, nobody knows the business better than the owner who's been involved with it, right? So
correct.
If they're not looking to stay and take an active role, they're looking to retire, well, we could bring them in a consultancy role, or they could bring somebody in. Let's say if they're a doctor, a physician, they could bring somebody they know and then train them for that period of time to do their job, right? Would that work as well?
It would, and bear in mind as well, when you talk about commercial financing, I'm glad you brought that up.
Yeah.
Because historically, at least in the last 10 years, so many businesses, so many buyers have acquired the assets of a business using SBA funding. Okay. So, and SBA requirements change from time to time. And so one of the things, for example, the SBA wants to do is to make sure that the money that they're putting out there is being used for the purpose it's intended. Okay, that's why they're guaranteeing it, and their internal regulations and requirements are written very tightly and very extensively. So if you've got an acquisition, if you're going for acquisition funding, then you have to bear in mind it's not a working capital loan. They're two distinct categories. Therefore, the SBA has some tight requirements, and in every deal, you check with your lender, you check with your attorney. I'm not going to try to go into specifics on it right now, but to be sure that what you're doing with your predecessor will not run afoul of the covenants that are required by the SBA. So in other words, as you go out for financing, then one choice you have, okay, so what you mentioned about continuity of management, in certain private equity funds and certain private equity deals, continuity of management actually drives the deal. And it often does with angel investors if they're financing an acquisition as well. And in traditional commercial banking, that can well be the case, because if you don't have the SBA involved, it may not be necessary to so carefully distinguish between the use of funds, the purpose of the loan, because in both cases, it may be more valuable to the lender to know that you're going to have continuity of management. Now, with that said, okay, yes, consulting agreements are incredibly valuable. And again, that is one of the collateral agreements that is almost always associated with an acquisition and a lower middle market deal. When you have got a closely held acquisition of assets of less than 10 million, seven-figure acquisition, 6 or 7 figure acquisition, the inevitably you are going to have some type of employment, consulting, or other collateral agreement, and you're going to have provisions, non-compete provisions, for when the previous owner, is done working with the buyer as well.
Right. I appreciate you going in depth. Let me touch a little on working capital. So a lot of people, when they look to acquire the business, also look to, pull out some money, essentially, not only to pay themselves and their directors, cover professional fees, but also build a capital pool. So if we have some money left from the business, let's say 200, 300,000 cash flow left after servicing the debt and covering everything, can we get a working capital loan and use that for essentially what I just talked about, paying yourself, your directors, and building a capital pool?
Well, again, I'm talking about the legal aspects of a deal, but I will say that yes, I do see that happen fairly often, many times as an immediate follow-on to, you may not close on both pieces of financing at exactly the same time, but working capital loans are very, very commonly associated with an acquisition. I mean, it's kind of a way of the lender helping to make sure the buyer gets off to a good start and is meeting their debt service. They want to make sure they're properly capitalized as they go into a business they haven't been running before.
Right. So I appreciate that. Yeah. So in regards to due diligence, one thing for many is that they don't have much money to spend. How can you ensure you're not wasting much on a deal that won't come to fruition? As you know, it's a numbers game, Andrew.
As a deal that won't come to fruition. Well, how can you make sure? Okay. This is the thing, is that we're all risk takers in this process, right? And the attorney's role is more as a risk manager. The attorney, however, cannot guarantee that a deal is going to close. One approach I was taught very early in my career, many years ago, was never to kill a deal as the attorney. You do not have that role. You're not the closer. You can't guarantee the close, but you don't do anything that actively would cause a deal not to go forward. And that means that as the attorney, you have to be very proactive about staying on top of, 2 a.m. emails. And if you're asleep, first thing you have to do when you wake up in the morning is check to see what's happened overnight in the course of a deal. Now, your question was, how do you make sure that you're not wasting money going through due diligence? As an attorney, as a business intermediary myself, I don't believe it's ever wasted money, because it's one of two things. It's either a deal that you successfully close and can get excited about when it's done, or it's grist for the mill. It's a lesson learned. It's something that it's a learning experience you can come away from, and what you have to do slightly differently the next time you go through the process. So I understand that. I think that I'm going to be really candid here, Valentino. I think there's a tendency on the part of both sides when they look at the cost of due diligence, whether it's for legal fees, accounting fees, valuation services, getting a quality of earnings report. Of course, in the lower middle market, that's not usually a viable piece of the deal, but in a little bit larger deals, it's very important. Whatever it is in the aspects of due diligence, it's not a good idea to be penny wise and pound foolish. It is very true that once a deal is done, that it's very rare that people pull out the documents and look at them and anybody gets sued. There almost has to be an open and obvious violation of a covenant within the deal, a rep and warranty or a non-compete, in order for there to be litigation after the deal closes. But nonetheless, there is a price associated with getting it done. And I think it is to the benefit of the buyer to not be penny wise and pound foolish, because the attorney is going to be on your side as you go through the process, and they're going to want to get the deal done too.
Andrew, I like what you said, a lesson learned or a deal closed. And that's how people got to look at it. Talking about reps and warranties. Now, we look to incorporate seller finance. Reason is there's some owners that are looking to take a payment over a series of years. Think of it as a retirement plan. Not only that, it saves on the capital gain taxes instead of a lump sum. Taking that into consideration, can we enforce some rep and warranties in the seller finance to serve as a liability clause? What I mean by that is that if we find anything, any skeletons in the closet, basically, could we deduct their holding equity or stop paying it? I don't know. Any insights from your experience?
Oh, absolutely. I love that part of a deal, actually. You can get very creative with it. You can become very creative with it. I think, again, that's a place where an attorney and possibly an accountant can bring a lot of value to the transaction from their experiences and the many different ways that costs are adjusted for earnouts and indemnifications or escrows or reductions. I mean, there's so many different things that you can do with the seller financing portion of a deal. Now, the SBA is going to limit that to a certain extent if you use the SBA, but the more seller financing controls the deal, the more creative you can get and the more that you can potentially save money or buy a more profitable company when you come into it.
Right. No, I like that. So, okay, here's one. So in regards to the legal entity of the business, is it okay if we file prior to closing? I've heard investment bankers say you can file for an LLC in about 24 hours. It costs about $2,000 though, but you could do that in about 24 hours. What's your insights on that, Andrew?
Of course, yeah, absolutely, you can. The question is, how does it impact the deal? I've had deals where the name was so important to, and that's not uncommon, but the name was so important, not just of the business, the DBA, but also the LLC. And the reasons for that were varied and many. But so I've had, it's not been an unusual circumstance for me to have the seller in initiating the process of forming an LLC and establishing it on the day of closing, actually. And now you would be wise to have had preferably internal counsel create the framework of an operating agreement, which is going to be executed at the same time. But it's something that generally, it seems to me, is best to contemplate whether it needs to happen immediately before or immediately after closing. Obviously, you have to have an entity to put it into, but sometimes you may want to do a two-part transaction where you transition the assets from you buy with an existing LLC, and then you transition them to another LLC that has the same name as its predecessor. Does that make sense?
It does.
Okay.
Okay, so moving on, can you touch on what are the most common things that breaks deals during the negotiation phase, and from your perspective, advising people?
Well, the number one thing is problems with financing. I mean, I think that's probably obvious. And this is why, and that becomes so important. Remember, when you draft an LOI, that the seller, as much as anything, if they like the price, okay, then the next most important thing to them is going to be that the deal is going to be able to close, that the financing, whatever financing it is going to be available. So the opportunity to work on seller financing comes very early, before you even present an LOI. Other than that, gosh, I mean, there are so many things, but I have seen deals blow up, largely because in due diligence, you discover that there are problems accounting for receivables, that there are problems in other aspects of accounting for the deal. I think you want to know all these things before you ever present an LOI to the seller, to the extent possible. Get as much of the due diligence done on the front end, and then you have less risk that it won't close. I'm going to tell you something. Of the 20 to 30 deals that I've closed as an attorney, I've only had two that didn't actually close. So every other one has. And I think the key is, once you've signed the LOI, you get financing lined up. You're a good creditworthy buyer. You just keep both of you want it. It's a marriage. You're engaged at that point, and you're walking to the altar.
So okay, circling back a bit on the structures, what's the best structure for what we're doing? LLC, holdings company, LLC structured as a C corp or S corp?
It depends. It really depends. It depends on what your intentions are. It depends on whether you are buying net operating losses, for example. It depends on whether you're using qualified or non-qualified benefit programs for the owner and what exists today. So a lot of it depends on the tax structure. Most of the deals that I have done and that I see have been done with pretty simple structures, with LLCs that are treated as S corporations. That's been the most common that I have seen. An LLC is so functional today in all 50 states that it's rare that there is value to creating a traditional domestic corporation unless the potential for an IPO is foreseeable on a reasonable time horizon within 5 years. With most companies in the lower middle markets aren't going there. So most of the time it is going to be an LLC, but the type of tax structure that you use is something you need to spend some time with your accountant to determine.
Right. So in an overview, in a nutshell, we're looking to acquire multiple businesses and exit within a time frame of 5 to 7 years. Not only that, we're going to have a board of directors advising, sitting on there. So what do you think is the best approach for that specific model?
Yeah, so you're talking about the potential for using a holding company or maybe a series LLC, perhaps. Are you familiar with the series LLC concept?
No, I'm not.
Okay, so a series LLC functions a lot like a holding company. It has a parent LLC company, and then it can put many others of different types of entities into underneath it, so they can be consolidated for tax purposes, and so that there can be intercompany transactions that all roll up into the original company. Honestly, I have not used that structure myself, only because my clients have already made their decisions about the structures they were going to use, and they didn't consider it. So I can't give you a deep insights into holding company and series LLC structures, but it sounds like what you're talking about, that would be a good fit for.
Yes. So I appreciate you touching on that. I'm gonna have to expand a little more, but that sounds great. Now, one thing I want to touch on, though, we are building, or we are a management company. What I mean by that is that we don't look to get involved in the day-to-day, but manage these companies. So alongside that, we'd be charging a management fee, right? And I've heard 7 to 10% is standard. Is that correct?
It depends on the business. If you're talking about in healthcare, that's typically, very, very reasonable.
Right. And from what I
Sometimes
heard,
I've seen healthcare management companies actually even a little bit higher than that.
and
So,
from what I was told is from the monthly gross revenues. Is that correct?
yes. And I mean, again, when you say 7 to 10%, 7 to 10% of what? Are you talking about off gross revenue?
Yeah, monthly gross revenues.
Yeah. Yeah. So, and that's, of course, going to be a pretty healthy fee, but they're very profitable companies. So a 7 to 10% slice, when your overhead of the company is fairly low underneath it, is quite reasonable.
What if there's high overhead? What do you think is a reasonable fee in the 12-15%?
Oh, no. I mean, if the overhead is already high, then you have lower profit margins, and you can't, and the company can't afford to be, you can't siphon off or take out as much for a management fee as you can. I mean, it doesn't work as well where you have low margins. You couldn't do a 7 to 10% management fee, I don't believe, in the grocery business, for example. It just wouldn't be profitable to the company, but at the end of the day. Now in healthcare and real estate, I mean, you've got some wide margins. Other professional services, sure. Those are the types of businesses where, higher level management fees seem to work.
Right. Now, do we pay our CFO for taking care of the books of the business from the management fee?
So, okay, let's make sure we're on the same page here. So you're talking about a holding company type of structure that owns several businesses,
but manages them.
I'm sorry?
Yeah, so basically, a holding company. So we look to, okay, let me give you the picture, right? Let me paint you a picture.
Please, yeah.
So we'd have let me give you an example, company, let's say Healthcare Co., right? This is the parent company. Let's say Healthcare Co. is looking to diversify into 5 different sectors. Let's say 3: hospitals, home health, and physician offices, which each would go in their own subsidiary, right? Now we're going to have a board to oversee it all, as there's too many for just one person. Not only that, we're looking to manage these companies, meaning there's going to be management in place for them. We're not looking to get in the day-to-day, but we do need a charger fee to cover the services. Right? Okay. Taking that into consideration, we're not looking at, and we're looking to go public in the next 5 to 7 years. Okay. So what would be,
Well, you're talking about, so this is something I would commend a conversation with your tax advisor over. It sounds like the prospect of setting up a C Corp is maybe very wise for you, given the type of structure you're talking about. you're a pretty unique entity. There are others
Right.
you'll be competing with, but you're a pretty unique entity in the overall marketplace. And it may be that a C corp is better suited to what you're doing. Okay,
Hmm.
that's not the direct answer to your question, but that goes back to an earlier question.
Right.
As to the question, can you repeat the question that you wanted me to answer now? Oh, about paying the
Yes, the
CFO.
CFO, do we pay him from the management fee?
Well, okay, so traditionally, and I think, um, you know, again, I think I would commend a conversation with other advisors on that, particularly the
Right.
accountants, and particularly those that don't have a stake, don't and giving you an answer to that. So
Mhm.
it's kind of like using your in-house counsel to advise you on bringing in external counsel. You want to go to whoever's on your board that has CFO experience and ask them how to structure it. The challenge there is, okay, so if you think about the CFO, look, in my mind, a
Yeah.
CFO exists for the purpose of creating the financial picture of your entity to advance the goals of obtaining further investment capital for your company, whether it's a straight exit, a sale of the company, that is, or whether it's to go public. And you need the right CFO depending on where you want to go with it. Now, you got so if you want to go public in 5 to 7 years, do you necessarily need a CFO who has IPO experience? I'm going to say no, but what you do need is a CFO who has that rapid growth stage experience positioning a company that could go public, and has either raised venture capital or private equity funding that put a company in position to go public, and B, has connections with firms and associates, colleagues who have taken a company public. That's what you need in the CFO. How he gets paid, I think that the answer to that question is above my pay grade. I've negotiated agreements for CFOs from where they've been paid, and but I'm representing the CFO, and they all like to have a healthy salary and skin in the game at the same time. So, where that money comes from depends on your entity structure for sure. And
Yeah,
actually, I've got some people that might be helpful to you and advising you on that conversation if you want to have that discussion offline.
yeah, that'll be perfect. I just want to chime in real quick, Andrew. And so the CFO, as far as taking care of the books of the actual business, not as far as them getting compensated. As far as them, as far as the books of the subsidiaries that we will acquire, they're the one that's going to be managing that, correct? And also, if the businesses that we acquire, they don't have a specific, firm that handles the booking, and we prefer to handle that. Is that something that the CFO would handle, or is that something our in-house accountant would handle?
Well, okay. So um, I like in-house CFOs. Okay, personally, I mean, outsourced CFOs can be great too, but when you're really looking at raising capital and acquiring other businesses, um, to me, the best scenario is to have a CFO in house. So that person has overall responsibility for the books of the company, but underneath him, you're very likely to have a controller who is the person who actually manages the keeping of the books, manages um, the financial statements, and the CFO has a much more strategic role. The CFO, you want to have overall oversight of budgeting and strategic planning and all your future performance. But so it's a combination. And when you say manage, I think from an overall standpoint, an overarching standpoint, yes. But when it comes to hands-on management of closing the books and presenting the financial statements, I think your controller is the one who would do that. Did that answer your question, or was it a little different?
No, absolutely, it did. It did. And also, as you know, a lot of us starting out, we're fairly new and we hear a lot of chatter. It's kind of hard to, disseminate what's true or not and what's accurate. So we've been hearing that to make an acquisition, you're going to need a CFO and an in-house accountant to actually sign off. The bank wants to see that. How true and accurate is that?
Wow. Great question. I think that the CFO role is vital in the type of company you're describing. Not having that person internally is probably very much a risk. Now, a lot of it here's what you do in my estimation. You you network to find your CFO, okay? And I've done a lot of work through groups like B2B CFOs in the past, and there are a ton of, ICFO. Let's see, my ICFO is another one. They're fantastic, and all the big accounting firms, they have alumni that are serving in these outsourced roles. You've got to it's a talent acquisition process, okay? And it is a process, and it's very much like the talent acquisition is very much like the business asset acquisition process. And you need to work through it in the best way you can for yourselves. I have seen companies that are in the place and the phase of business growth that you guys are describing, utilize outsourced CFOs who are kind of dividing their overall salary into 3, 4, 5 pieces amongst clients. And then they're going to come aboard full-time, or they have 2 jobs. They raise money, number one, and if they don't stay with you, they need to be putting their own successor in place. Okay, so you can go the outsourced role early on, in my opinion, but it's got to. But then the reason why that can work is because CFOs, more than anyone else in the M&A environment, tend to have good relationships with bankers. So that's what you're looking for. You're looking for a person who's got those relationships, can make the right connections with you, knows the underwriting process, knows the numbers that matter, and knows how to advise you on how to get there.
Yeah, you said something interesting there, Drew. You said that the CFO would actually, something to the effect of select or pick, their successor. What do you mean by that exactly? And also, I've come across some CFOs that have, investment banking background. I see that more often than not. But yeah, so can you just touch on that real quick?
Sure.
Are you saying that, before they leave us, that, are they obligated to have a successor in line, or is that something that we work out in the contract?
Okay, so candidly, the interesting thing is that most of my legal clients in M&A, in the M&A world, have been on the acquisition side. But I have also represented several CFOs in negotiating compensation agreements that were coming aboard on the sell side of a deal. They were positioning for an exit. And so if you're positioning for an exit, you're going to be the last guy standing, of course, as in your role, because there's not going to be your role. It's going to be a new company that has their own CFO thereafter. On the acquisition side, okay, what I have seen from my friends in the outsourced CFO world is that they come in and then they advise their client on deal opportunities, what they need to do to have their books in order, what they need to find in the books of the target company, and they're doing this. It's a 25% time commitment, 25% time commitment. Okay, as you approach the acquisition, either A, they're going to be part of that deal post-acquisition, or they're not. It's going to be one or the other. If they're not, either by their choice, which they probably would have let you know what their terms are, should have on the front end. If it's their choice, then you need to have them, and even if it's your choice, you need to have them finding the person, identifying the person, training the person that is going to play that role for you going forward afterward. Now, the best case scenario, of course, is that you've now bought a company that is so profitable, and inside the budget are all the terms of compensation that the CFO would need to stay on with you. Okay. So that's the ideal situation, but it doesn't always work that way. And once you're established and you have I'm talking about kind of your first deal situation. Once you're established and you have a full-time CFO, this is no longer a question. They're no longer training their successor. It's just in the very initial acquisition that you make that you have to keep that consideration in mind.
Hey, Andrew, those were some amazing insights. Now, I got 3 last questions I'd like to run through, if that's okay.
Sure.
Perfect. One would be, I was told that LOIs are non-binding except for certain provisions, like an exclusivity period, no-shop provision, where we're undergoing due diligence, right? Are there other things to incorporate in there?
Wow. Okay. Yeah, I kind of, geared this, my own preparation to beyond the LOI, but I'll touch on that quickly.
Sure.
Obviously, I'm not here giving per se legal advice. I'm giving you some analysis of what legal work looks like.
Just base level.
Yeah. Okay. First thing to remember is an LOI is an offer. It's a letter of intent. Okay. And so what keeps it non-binding is either A, the non-acceptance by the seller, okay, or B, which you want to have is acceptance of the seller with provisions that state what is binding and non-binding. So in the state of Indiana, where I'm licensed, for example, it's a very much a 4 corners state, which means if something is contained in the 4 corners of the document, that's what the contract is. It's not a conversation about what you thought you agreed on, what the circumstances were, and outside conditions. It's what's in the document itself. So an LOI, once signed by both parties in most states, is itself a binding contract. Now, the traditional LOI says that exclusivity periods, et cetera, price are those terms that are binding. And the LOI is functional because it's dynamic, because the parties anticipate that in going through due diligence, there are going to be some changes in the terms, and most definitely there's going to be a much deeper dive into the terms of acquisition. So you can put anything from the standpoint of an attorney licensed in Indiana, you can put anything in an LOI, but your best bet is to keep the traditional binding and non-binding terms separate and work forward from there.
Right. Now, I heard a lawyer can look at our documents but can't draft our documents if they're in a different state than us. How true and accurate is that?
Well, if you're doing a deal that is solely a intrastate business deal, then you would not want an attorney who's not licensed in your state drafting those documents. Okay. If you are engaging in interstate business, then I don't know any attorneys that are licensed in all 50 states. Okay, attorneys for in every state form LLCs in Nevada, Wyoming, trust in South Dakota and Delaware, C corps in Delaware, et cetera, series LLCs in Tennessee. So it depends on the transaction, but especially if you're dealing with provisions of real estate, it behooves you to have local counsel involved in the transaction, for sure.
Right. Okay, second question would be, many people are scared of the PSAs as it's binding, right? But if we find some last minute things that totally change the outcome of the transaction, either on the seller side, where we found out something, skeletons in the closet, or the buyer could not get the funding, can we include a clause where we can pull out from the deal with no repercussions if there are no breakup clauses in place?
Okay, I'm going to have to ask you to ask that question a little bit differently. Yeah.
Okay, so
I'm not
right.
Totally follow.
So we got the LOI done.
Yes.
Right. We did the diligence. We're moving on to a PSA stage, purchase sale agreement, finalizing. Now, there's no breakup fee involved, right? So breakup clause, we already know, either mutual or seller buyer. If that's not in place, and let's say I cannot get the funding for the deal, or we find some last minute things with the seller, is there a way where we could, decease the contract and not get affected?
Do it all the time. Yes.
Yeah.
Simple answer is it's just all in how you draft the agreement. Yes.
Okay. Perfect.
Okay.
Perfect. And last question would be, when it comes to drafting up the shareholder agreements, what are things that can protect us? Just base level, no legal advice, but I've heard of an equity buyback clause. How about a clause where we can fire them if they don't meet expectations? What type of things should we include or look out for?
You can fire who? Other shareholders?
Our board, right? So we're giving them equity. So essentially they become a shareholder in the company. They own equity in the company. Now, the way to go about it is essentially equity is given upon the first transaction. Now, once they hold equity in the business, could we incorporate a buyback clause? And also, if they're not meeting expectations, can we fire them without any issue?
Okay, so to answer the first part of that question, a buyback clause, absolutely.
Okay.
It's just a question of drafting.
Right.
And then the other part is, how do you go about executing that? Does the CEO have the power to make that decision? Does it require majority board approval? Does it require a supermajority? Defining how you go about the decision process is really important. As to firing them, that's an interesting. You want board positions, So firing, kind of carries the connotation of employment. Obviously, they're not employees, but I understand what you mean, and you want to have them serving at will, at the pleasure of the governing authority of the board. So how do you do that? I mean, that's like, it's like impeaching a president or firing your congressman, or what the key
Right.
again is the process that you put in place. In my mind, you want to have at-will provisions for every board member. You want to have at-will provisions so that they can be removed from the board. That's number one. Number two is that you want to be very cognizant of how what that means in particular situations. So, do you want to separately draft for cause and not for cause provisions? And typically, I think it's a good idea to have that because your board is just too important to you. And if, say, someone was involved in securities fraud, sexual harassment, litigation, something like that, you want to be able to have a removal for clause provision that changes the terms so that it works in your favor.
Talking about, you were stating it's like impeaching a congressman, the president. Do they have that much power?
Who?
The board members. So what I want to make it clear
No. But the thing is, no, they really don't.
What I mean, real quick, Andrew, is that do we have to be very specific with the people we're bringing on and giving equity to, to not go through a whole process that becomes a big issue? That's what I'm trying to say, like doing things.
Are you familiar with shareholder oppression litigation?
No.
Okay. This is the problem. Okay. This is the problem. There are minority interest rights. Okay. And they vary from state to state. So you have to be very careful about what you do. In most states, okay, those minority interest rights are very limited, but there are all kinds of exceptions that have been cropping up in the law over the last 5 to 10 years that if you freeze out a board member, if you freeze out a shareholder without paying them what they believe is fair market value for their equity, then you first of all run the risk of litigation. Secondly, they may have a cause of action depending on what they can establish was the factual backdrop to it. So I do think that even though they realistically don't have that much power, the risk that is associated with having I can compare it to some things, like
Andrew, sorry to interrupt you. So essentially we're not looking to say, hey John, you're fired, right? They'll be compensated for the time they served. If they hold any equity, it'll be paid out. But I'm just saying, if we find a better prospect later down the line that meets the criteria of the size of deals we're looking to acquire, can we be like, hey, John, thank you for your time. I appreciate your involvement. Here's your check. And then bring in the other guy without any issue.
Yes, but I think you're wise to have board succession provisions that are very that anticipate the purpose and timing of when that might happen. I'm a lawyer, so that's what I do for a living. Mm-hmm. But I've seen so many times. Look, I've served on a lot of nonprofit boards. I've drafted lots of governance documents for nonprofits. The biggest issue they run into is with the lack of turnover on boards, and people get entrenched, and it can be very problematic. So planning for their exits is not a bad idea, in my opinion.
Right. So I want to make this clear for people. This is not a joke, right? There's a lot of seriousness. There's a lot of things involved in it. Now, touching on succession and growth, we're not looking to stay in the lower middle market range. We're starting out there, but the goal is to, grow bigger, right? Taking that into consideration, do we need the big guys from the beginning so we're already prepared for when it comes? Or can we go basically, upgrading people as we go? What do you think is the best approach?
Wow. But is that a loaded question? Because I'm kind of a transitional lower middle market to middle market, advisor. So, I have my own, I'm going to be candid and say my biases are going to come into play here.
Yeah, no problem.
And say, I think you go with the guys who are the experts where you're at today, plan for their successors. I mean, my experience with getting the big guns involved too early is that they want to dominate the transaction, they want to shape it for their purposes, and you end up. I think you run a risk of ending up with something, an animal that doesn't look anything like what you started out to create. That's my own personal bias, but it's also my observation and experience.
Right. No, you're right on that. So I was told as well, big four guys, you could get boutique firms or guys who work at boutique firms that are more specific, more geared toward this amount of deals we're looking at. Okay, let me make it more specific. For example, we're looking at lower middle market deals between $1 million to $20 million, right? So it'd be better to get, like you said, somebody who's adequate for that deal range instead of bringing $100 million to $1 billion guy, because the guy who's in the 1 to 20 knows what to look for and how it operates. The other guy, that's not a drop in his bucket, so to speak, right? Can you touch on that?
Well, yeah, I mean, yes, I want to agree with you wholeheartedly and say that's the right conclusion. But don't mistake that for the idea that someone like Kevin O'Leary or Mark Cuban, they don't know the $1 million to $5 million. I mean, they're called sharks for a reason. And these people can play in much, much, much bigger space. And they have their own companies that fit in that bigger space. But that doesn't make them good partners. And I think, it's kind of like, to me, I continue on with the Shark Tank analogy. I think Shark Tank is beautifully instructive about a little bit about how a process of accumulating capital works. But it's also beautifully instructive in the idea that look, I mean, how many sharks do you see? You see some turnover, some seats changing hands. They're all celebrities. They're all people that have been in that space for a very long time. Okay, that very wealthy people. You don't see any of the people that had that they made investments in coming in and becoming sharks later on. And why is that? Okay, because part of what they are selling or buying, whichever way you want to look at it, is they're trading money for dominance. So when that money comes in, there's a lot more control that's being given away than you'd ever think about in a 30-minute episode of Shark Tank. It's the same way, with the Prophet and other examples of people that are doing that are widely known out there. So no, in my mind, there's an abundance of talent out there in that $1 to $20 million market. There are an abundance of companies out there. Why go to the guy that can make you rich quick, only to take away your dreams of stability and long-term wealth accumulation?
Right. No, that's a great point, especially for a guy starting out. They see a shiny object and forget about everything else. These are sharks for a reason, right? Now, I as we go talking, I got a couple last questions. I don't know if you have the time for them. I want to be respectful with that.
Yeah, I mean, yeah, if we can wrap up in the next 10 minutes, I'm okay.
Perfect.
I'm flying out early tomorrow morning, so
Sounds
I got
perfect.
some things I got to get done. But I've still got 5-10 minutes.
Okay, let me touch on investors very briefly. K1 for investors, I've heard they don't like them. Do you have any insights regarding that? You know, because they get taxed there on an individual level, if I'm correct.
I don't have much to offer on that front. I just don't. Of course, I'm familiar with them.
Right.
I don't know how investors react or respond to K1s. I haven't had those conversations. So.
No problem. No problem. Last thing, in regards to, there's equity gaps involved in these transactions. How can we connect with investors that cover the soft costs of due diligence? How do we structure paying them back?
Wow. That's a great question. That is a great question. Now you've raised the question that may be the next iteration in my business because everybody wants those costs covered, right? And, I mean, candidly, the only way that I've seen it done, it's one of the biggest frustrations of the last 12 years of my practice and work, is that the only way that I've seen those soft costs covered by a third party is by giving up a lot of control over the transactions and your entity. And if you don't want to do that, don't sell out your control for somebody to do that. That's the one thing I would tell you. But that said, I think there has been a big gap in the marketplace and an opportunity for investors to play that role. And I'm confident that there are people out there. And if you find out before I do who the best resources are for that type of investment, please let me know.
Hey, Andrew, I appreciate your time. Thank you very much once again for your time, for your insights. These are things that, people hear here and there, but nobody really goes in depth. And like we say, we're looking to clear out the misconceptions and the misinformation. So I appreciate your time again.
Happy to do it, Valentino. This was a great time. I've really enjoyed it.
I appreciate it. I'll send you the link. Yes.
I look forward to
Appreciate it, Andrew. Appreciate it.
Thank you. It was great being on with
one last question, Andrew. Would you be open to another episode later on the road?
Absolutely. I would look forward to it. I think, hopefully you'll accumulate some questions from some of your listeners. And
that's what we're looking to do. Yes.
Okay.
Perfect.
I love it.
Thank you very much. Thank you, Andrew. Take care.
Have a great night. Take care.
Too.
Bye-bye.
Bye. Billionaire acquisition mastermind. Who the hell is bringing on attorneys providing legal insights like that, man? We're over here asking the real questions, not no surface level. We want to dig deep and provide you what you need so you could go out there and crush it. Hey, our actions speak louder than our words. We're not telling you, we're showing you.